after I'm done grading. I know that the first assignment is always, you know, in a new class is always the one that's like so stressful because you don't know what they're asking for. You don't know what they're looking for. So if you ever have questions about it, feel free to email me and I'll get back to you and let you know my preference. But I think you guys are going to find that I'm pretty laid back as far as that is concerned. Mainly, I'm looking for the content and making sure that you guys are understanding what's going on. And I'm looking for, you know, a way to grade you basically. So that's basically what it is. So a way to judge how the class is going. So we will have another assignment that will get assigned tonight. It's due next week. Like I said, I'm going to try and get the first assignment graded tomorrow evening so that you guys have your feedback on that before you start your other assignment or before you turn your other assignment in. So if there's any tweaks that you feel like you need to do, you can do at that time. Let's see. We'll talk about the assignment that's due next week. We'll talk about that. It's in your modules under assignment 2, but we'll talk about that at the end because I want to go through the chapters first, and then we'll go ahead and talk about the assignment. All right. Did everybody get a chance to read chapters 9 through 12? Hope so. All right.
I just skimmed through it really.
Skim through it. Okay. Okay. So let's go ahead and get started. So chapter 9 deals with the nature of traditional and e-contracts. So we're going to start getting into these contracts, and this is a fairly big part of business is contracts. So this information, as we move through, you're going to see how it pertains to business as well as you as an individual. So there's some good information in the next few chapters that you should really pay attention to. So a contract is a written or spoken agreement that's intended to be enforceable by law. To have a contract, you must have at least 2 people, an offerer, which is the party that's making the offer, and the offeree, which is the party who's receiving the offer. A contract is considered executed when it has been fully performed on both sides. So all the details have been worked out and both parties have signed the agreement. A contract has 4 elements that are required in order for it to be enforceable. The agreement, which is the mutual assent by the parties, which includes an offer by the offerer and acceptance by the offeree. Consideration, which is a legally sufficient bargain for items such as money or property in support of a promise. And contractual capacity, which is a contract cannot be enforced against parties who lacked contractual capacity when they entered into the contract. And we'll be talking about that more in detail later on. Lawful object, if the object of the agreement is not lawful, then the contract would be void and not enforceable. Let's take a look at case 9.1, Facebook Inc. versus Winklevoss, and it's on page, for my book, 205.
173 for ours.
Thank you. 173. And I am going to save my voice today, so I'm going to let you guys read through it. I'm going to give you a minute or so to let you guys read through it, and then we'll discuss it when you're done. So.
I'm sorry, I had to go grab my food from the microwave. What are we doing now?
We're reading case 9.1 on page 173 or 205.
Thank you.
Mhm. Have you guys already heard about this case?
Yes.
Pretty big. It was
Yeah.
a pretty big one, right?
Yeah.
Did they have this on the news? Or
I don't remember where we heard about it. It's been years ago, of course, but
Wasn't it? I think it might have been in the movie about Zuckerberg.
it might have been, yeah. But this, so basically what's happening here is they wanted to get a piece of Facebook, and then they came to an agreement. They had a bunch of lawyers in the room. They decided on an agreement, and the agreement said that they would give up their claims. The Winklevosses would give up their claims in exchange for $20 million in cash and $45 million in Facebook stock valued at $36 per share. Well, then when it went crazy and all of a sudden the shares increased, oh, I guess it doesn't say what the shares were, but it went crazy and its value exceeded 30 billion. They freaked out and said, we didn't get enough money for this, and we want to back out of our original agreement and do a new one. And the court said, no, you did an agreement, you had lawyers present, everyone agreed, and at some point this has to end, and this is what's happening. So do you think the Winklevosses should have had their claims of fraud decided by the court?
Well, first of all, it says that the shares were actually 888, which is much less than what they were given. So that part's confusing to me.
Yeah. So they said that when they were given the $45 million of Facebook stock, it was valued at $36 per share. And they said that the reason that they wanted to back out of the agreement was because it was booked at $8.88 per share as opposed to $36 per share. So they said it's fraud and we want to back out of the agreement. They're looking for
They're looking for an out.
They're looking for an out. They're looking for something that will make that contract void so that they can start all over. And basically that's what they came up with. They said, well, it's fraud because it says $8.88 and we said $36. So he misled us. And so, or Facebook misled us. And so, basically they wanted to just get out of that contract that they signed so that they could get into a better contract. Do you think anyone acted unethically in this case?
Nope, they had a deal.
I agree. Anybody else?
Didn't they steal the initial idea of Facebook from them though, with Connect You?
And I don't know about that. I mean, there was a lot of stuff that was, and I don't know how true the movie was, but there was a lot of information out there, and I know, I'm sure you guys know that Facebook has been sued every which way it could be sued because of something or another. And this just goes to show that Facebook, when it started, there was a couple other platforms out there, but none so successful as Facebook. And when it started, it was fairly new, and it still is. Its situations are fairly new. So there's always stuff coming up, and there's always new legislation or new laws that they have to abide by as we figure out the internet and figure out how things work and figure out how social media works. So it's really, that's pretty much the reason that it's always going to be in the news, and it's always going to be having an issue with certain things, is because it's right out there in the forefront. So it's setting precedents for other platforms like Facebook to come. Okay, so contracts, they come in all shapes and sizes, and they all differ somewhat in how they're constructed, enforced, performed, and discharged. However, every contract will either be bilateral or unilateral. And I don't know about you guys, but this part is kind of confusing. The difference between a bilateral and unilateral contract. A bilateral contract is a promise for a promise. And the promise of each party executes the contract. So I say, I promise to give Bob something, and Bob says, let's see, how do I want to say this? So I say that I promise to pay you, Bob, $100 if you promise to do something for me. If you promise to paint my house, and you say, okay, then that's a contract. It's right there, because I've given a promise and he's given a promise. I promised to pay, he's promised to paint my house. In a unilateral, it's a promise for an act. So the contract isn't actually recognized until the act is completed. So if I say, hey, Bob, if you come over and paint my house, I'll pay you $100. I hope you wouldn't take that deal. But, and if Bob said, hey, you know what? We'll see. That's not a contract. He hasn't promised me anything. So if he comes over and paints my house, then it's a contract. But let's say that Bob gets halfway through my house and says, you know what? This sucks, and only for $100, I'm not doing it. And he walks out. So now what grounds do I have to come back on him to have him finish it before I get paid? Or what grounds does he have to collect since he didn't complete the situation, the painting job? So a unilateral has a little bit more going for it, as far as it gets a little stickier and a little trickier. So if a person performing the act in the unilateral contract doesn't complete the act, it can create issues, and the contract can be revoked before the work begins. However, once it's begun, it's much harder to get out of the contract on either one of us, our sides. So it's sometimes difficult to distinguish between a bilateral and unilateral. Like I said, it's just really kind of difficult sometimes. You're like, okay, well, that is a promise and that is an act, and that's, whatever. So when that happens, it's always reverts back to the bilateral contract. So if, when in doubt, just call it a bilateral. Just kidding. If you're not
You gotta-
sure, that's what you would do. So Bob, $200 to paint my house? Just kidding.
An
hour, maybe.
For an hour? That's better. Okay.
So with that contract, it doesn't necessarily have to be written, it doesn't have to be documented.
So it doesn't necessarily have to be in writing unless it's a specific contract that is required to be in writing. And we'll talk about that more coming up in a little bit, in a couple chapters later. So let's talk about an express contract. An express contract is stated in oral or written words, so it can be written or it can be a verbal situation. Most contracts are express contracts. An implied in fact contract is when the agreement is inferred from the conduct of the parties. The elements of this type of contract are that property or services were provided and there is an expectation for payment of property or services, and the other party had an opportunity to reject the property or services and did not. So just think of this. I go to the grocery store, I fill up my whole cart, and I go to check out and I'm like, you know what? At this point, I don't want to buy these items. Do I have to? Okay. What if I try to walk out of the store? Now I do. Now I'm saying, okay, I want these items. I haven't rejected these items, and I'm ready to leave. So at that point, now I have a contract with the store and I have to provide payment for those items. So that would be an implied in fact contract. An example. That's a very weak example, but it's an example. So let's look at case 9.2. This talks a little more about an implied in fact contract. In my book, it's on page 209. And it's Wrench LLC versus Taco Bell Corporation. $177 for everyone else. And I'm just going to give you a minute or two to read through that. It's a long one, sorry. Yo quiero Taco Bell. You guys all remember the little chihuahua?
Yeah, I remember those commercials.
Gotta love it. So, one question I have is what would have made this whole mess so much better? I mean, taking it just right away.
If they had a contract to begin with instead of just a verbal one.
Exactly. And you know, sometimes that works in business, and I'm sure that what's their name, Rinks and Shields, I'll bet from then on they don't do anything for anybody without a contract, most likely. And that was a learning experience for them. I'm betting a written contract too. And but their situation, they're entering into this, they probably had emails back and forth. They may have had some, you know, information that way. They did presentations for them. They did a focus group for them. They did a bunch of stuff. So I'm thinking that's probably where the court said, you know what? You asked them to do this. They did it. And then you went with a different company. And then that different company took the idea that they'd already presented. And honestly, they presented that before Taco Bell even found them, right? They were already, it looks like they had already created this dog, and it was a character. It wasn't a real dog. Taco Bell went with the real dog instead, but they told them they were going to do the real dog before they even got rid of Rinks and Shields. But anyway, do you think Taco Bell acted ethically in this case?
No.
No. And what happened most likely was that the guy that contacted Rinks and Shields, what was it, Alfaro, he probably was doing it going, oh, this is so cool. And then he took it to VP, and VP said, no, we're going to go with the company that we already know, or whatever they said. So he had already started this on behalf of Taco Bell. So there's another issue for a business, from a business standpoint, that you have to make sure that you're allowed to make those decisions for them. So, you know, that kind of stuff can be a little touchy too. So from Taco Bell's standpoint, they could have said, you know, if you don't contract directly with our VP, then no contracts exist or whatever. They could have said that at some point as well. But because Alfaro was actually, or was he the VP? He was actually contracting them, or, you know, by a verbal agreement, talking to them about this stuff. You know, he was acting on behalf of Taco Bell. And you'll see in some contracts, they'll actually have something that says, are you allowed to act on behalf of your company, of this company? Are you allowed to enter into contracts on behalf of this company? Because some companies have been burned that way. So there are 4 categories that law can place a contract in. They can call it a valid contract, which means that it meets the essential elements to make the contract. They can call it, and it's enforceable by at least one of the parties. So somebody can come and say, you know, I need this to go through. It can be a void contract, which has no legal effect, and it's as if it had never been created. There's a voidable contract, which at least one party has the option to release the obligations of the contract. And an unenforceable contract. And if a contract is required to be in writing by the statute of frauds, which I was saying that we'll talk about in a little while, which I think it's chapter 12 actually. But it's not in writing, it's not enforceable. So if this would have been a situation where they were buying property, for example, then that contract would have had to have been in writing, and it wouldn't have been eligible for this implied in fact lawsuit. All right. Chapter 10, we go more into agreement and consideration of a contract. So An agreement is basically the substance of a contract. Agreement and contract are often used interchangeably. You'll hear people call them contracts, you'll hear them call them agreements. Same thing pretty much. So in order to have an agreement or a contract, an offer must be made. For an offer to be effective, it must have the following elements. It must have, the offerer must intend to be bound by the offer. The terms must be definite or reasonably certain, and the offer must be communicated, to the offeree. The offer must show the willingness to enter into a bargain by the offerer. The terms must be clear so that the offeree can determine whether or not they want to agree to the offer. The terms generally contain the identification of the parties, the identification of the subject matter and the quantity, the consideration to be paid, and the timing of the performance. These are known as express terms. Sometimes all of the terms in a contract are not actually spelled out, but they're reasonably certain. These are called implied terms. So the most important thing, in my opinion, of an offer or an agreement is communication. The communication of the offer has to be made. If it's not, then the offeree does not know that there's an offer being made, right? So an agreement is not made with just one party. The other party needs to know that there's actually an offer. So in the case that it hasn't been communicated, there is no agreement. Let's look at case 10.1 on page 218 in my book. And this is Martyr versus Lopez. 186, thank you. And I'll give a minute. This one's not as long. All right. How many of you have even heard of the movie Flashdance? Okay, cool. I was feeling a little dated here. Okay, so in this case, the actress or the woman that the movie Flashdance is based on, Martyr, she is paid $2,300. And I just want to read this part. It says, Martyr signed a general release contract that provided that Martyr releases and discharges Paramount Picture Corporation of and from each and every claim, demand, debt, liability, cost, and expense of any kind or character which have risen or are based in whole or in part on any matters occurring at any time prior to the release, the date of this release. So she basically signed her life away there. Basically, everything that's in there, she can't, no debt, no liability, no cost, expense, blah, 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 all that. So this movie ended up making, at the time that it was released, $150 million, which it's still being watched today. People are still buying the DVDs a little bit. So, there's a lot of money in that movie, and she got $2,300. So she sued for that. And of course, the court came back and said, you signed this contract. This contract says that you have no rights whatsoever. So do you think that Martyr acted ethically in bringing the lawsuit? I mean, we all want money, right? And who knew it was going to be $150,000 or $1 million and when it hit the box office? But she did sign that contract. And of course, it's always nice if we could see it in the future and know that signing a $2,300 contract is not enough. But she was okay with the $2,300 before it grossed $150 million, right? Did Paramount owe an ethical duty to pay Martyr more money after the movie Flashdance became a success? I mean, they could have been nice and been like, you know what? We didn't know it was going to explode like this. This is based on your life. And, here you go. Let's give you a little something. They could have done that. Did they have to after they made her sign that contract? No. I mean, ethically, we talked about ethics and how ethics is kind of a personal judgment in most cases. So if it were me, I would want to give her money. But, obviously Paramount wasn't that thinking of it that way.
So Cindy,
Yep.
it was kind of like a real flip of the coin, really, because she just signed the contract not knowing how much money they were going to get, right? So
Yeah.
she could have been like, hey, I want at least 25% of the cut,
She could have, and that would have been a really good act. And maybe, I don't know if she had legal advice with her when she signed that contract, but that would have been a really good idea for her, because they could have said, hey, wait a minute. We don't want you to sign a contract that just gives you this amount. You need to be able to get some sort of royalty off of this. And then she would have gotten more. So yeah, signing something like that would have been great. And the fact that she didn't is, a detriment to her. She should have, I mean, like I said, it's nice if we could see into the future and then we would know what we want to sign the contracts for. But, that's not always what happens. So
That's a hard pill to swallow.
what was that?
I said, that's a hard pill to swallow.
It is. Yeah, I'm sure. And, I mean, she has to see that movie of her life in all the stores and whatever, and all over the place. And people may come up to her and be like, hey, we saw this story of your life or whatever. And she got $2,300. So it's a kick every time she sees it. I'm sure that's how it would feel for me anyway. So, all right. So when the offeree receives the offer, they can either accept, reject, or counteroffer. So in this case, if she would have counteroffered and said, no, I want to, like Jack said, 25% of any proceeds, any money that you make off of this, then, that would have been a little different. If they accept the offer and communicate their intentions to the offerer, then the agreement is executed. To be considered accepted, it must be accepted by the offeree and not someone else. So I couldn't accept it on behalf of Cherie, for example. She would have to be the one to accept. It must be accepted in whole without any doubt that the offeree is agreeing to the terms fully and without any changes. And it must be returned to the offerer by the proper means. So there are certain means of, you know, you got to make sure that it gets back to the offerer. Otherwise, the contract, you know, like I said before, communication, it takes two. So if someone says, here's a contract for you, Cindy, and then I go, okay, and I sign it and I send it back to them and it never gets to them, it's not really a contract, right? Because they still need to know that I accepted. So a counter offer is a type of response that sets new terms for the agreement. It automatically will terminate that original contract, and the roles of offerer and offeree switch. So now it's, you know, if I were entering into a contract with Aaron, for example, then Aaron counter offered, then now Aaron's the offerer and I'm the offeree. So it would come back to me, and then I would have to communicate back to Aaron that I accept or counter offer or whatever it may be. So let's take a look at 10.2. This is about counter offers. Case 10.2 on page 221 in my book. Ellen versus Melvin. Oh no, that's the wrong one.
189.
189. Thank you. Okay, so in this situation, we have a contract that was brought up or made up, a purchase agreement, and Paul Ellen signed the purchase agreement offering to purchase real estate owned by John and Lindy Melvin. Okay, so when the Melvins received that contract, they wrote on it and they put, they corrected a name. They put that the property is to be sold as is, that the mineral rights conveyed by the Melvins were limited to the rights that they owned, and the property was subject to federal wetland easement and agriculture lease. So these are things that they've put in this, and they've initialed those and they signed it and they send it back to Ellen. So then the date of the sale of the proposed closing comes up, and they haven't heard back from Ellen, so the Melvins don't close. They don't sell the property. And Ellen says, well, why not? We had a deal. So what they've done by making all those things on all those changes, even handwritten on that contract, is they've done a counter offer, right? They've sent it back to Ellen, and Ellen did not communicate back. So remember, when they send it to Ellen, now they are the offerers and Ellen's the offeree, and he has to sign it that all the changes are okay and that he agrees to the counteroffer, and then send it back in order for the contract to actually be communicated. And that wasn't something that happened here. So one party's thinking, oh, okay, this is fine, whatever. The other party's thinking, we never received anything back. So the court basically said that, they couldn't uphold this contract because it was never fully executed. The counter offer was made and it was never accepted. And that silence is not something that is going to be allowed. Silence is not something that accepts a contract. You have to actually communicate back. So what do you think the consequences would be if silence were considered acceptance?
All kinds of stuff.
It could get really ugly, right? Because I mean, if the offeree sent a counter offer back and it was something crazy and then they didn't hear back and they just assume that it's okay and they're going to go forward with it because silence is okay, then that offerer now may have never received it and has no clue that they've entered into this contract. It could get really messy. Okay, counter offer isn't the only way a contract is terminated. The offerer could, yep. Okay. Yeah, that's right. So once both parties have agreed on the changes. So when you do a counter offer, that first contract is voided, but you're talking about just the mode of acceptance in general, right? Or the mode of delivery. So basically, if you think about it, this contract is something, especially with a purchase contract, this is something that's very important. You want to make sure that person gets it. You're most likely going to send it with certified mail or some sort of receipt so that they've received it and they have it, and they have that option now to sign it and accept that agreement. And then you would find out if it's signed. Now we have the internet, and a lot of things are being signed on the internet. So it's pretty instant. Like DocuSign, how many of you have used DocuSign or one of those kind of applications? So basically it comes to you, it says you need to sign this, you go through, you figure out what you sign, and if you're okay with it, then you sign it, and it goes directly back to whoever it needs to go to, and it's executed at that point because they've received it. They've received it. You get a little thing that says so-and-so has received your application, and here's your completed, and this is the fully signed, and all of that. So it's kind of taking away from that, but there are still situations where you would mail it, or you would hand deliver it, or courier deliver it, and get that signature so that person has received it, and that they accept the terms. So did that answer your question? Okay. All right. So a counteroffer isn't the only way a contract is terminated. The offerer could revoke it anytime before it's accepted. So let's say that I send an offer to Sherry, and I don't send it by DocuSign. I send it by snail mail, and it takes a little while to get to you. And in the meantime, I call you up and say, you know what? I was looking at that contract and I made some mistakes in there. I don't want that contract to go forward. Let's kill it. And you go, oh, okay, yeah, no problem. So then it's terminated, and that's fine. So at the point that it's accepted, so if Sherry said, you know what, this is good, and she signs off on it, and it comes back to me, at that point, the contract can't be terminated. It's done. The offeree could reject the offer. So if it's rejected, then it's no longer a contract. A rejection is generally not effective until it's received by the offerer. Again, we are talking about that, where it has to actually be communicated to the offerer. Operation of law can also cause a contract to terminate. If the subject matter is damaged or destroyed before the offer is accepted, the contract would terminate. So let's say I'm going to sell a car and I drop a contract, and the person is going to receive that contract, but before they receive it, before they sign it, I get in a car accident and the car's total. Do they have to sign that contract now? No. And I've lost a sale. So death or incompetency of either party before the offer is accepted would also terminate that contract. If the object of an offer is made illegal prior to acceptance, the contract would be terminated. The most common example of this is an interest rate or usury. That's set by the state legislation, and basically this caps the interest rate. And if the rate in the offer is more than that cap, then the contract would be automatically terminated. If an offer states a time limit in it, the contract would terminate if it's not accepted prior to that time. That happens a lot of times in real estate too. When we sold our house, when we were living in Vegas and we sold our house, people had time limits on their, because real estate was moving so quickly, any offer that came into us, we had a certain amount of time to accept. If we didn't accept it, that offer went away. It terminated. So there are situations where there's a time limit on an offer and you have to accept it within that certain amount of time or it's no longer an offer. Consideration is essential in a contract. It is the item that's being exchanged for the promise. If you don't have consideration, then there's usually no offer to be made in the first place. So if I don't have money to buy a car, then I'm not going to buy a car, right? If there's not a car to buy, then I'm not going to buy the car, right? So consideration has to be in the contract. To have consideration in a valid contract, it must be of legal value and there must be a bargain for exchange, something for something. So think about a gift. A gift lacks consideration because it's something that's being given. There's not an expectation of receiving something back. So in that case, it's something for nothing and not something for something. Let's take a look at 10.3. This is on page 226 in my book.
Is it the Cooper versus Smith one?
Yes, it is.
Okay.
194, thank you. All right, so in this situation, Cooper and Julie developed a romantic relationship, and Cooper proposed marriage to Julie and she accepted. And then he received $180,000 settlement for some injuries. And after that, he moved in with Janet and Julie. And over the next couple of months, he purchased a number of items for Julie. So I wanted to go over these items he purchased. He purchased a diamond engagement ring, a car, a computer, a tanning bed, and horses. And then on Julie's request, he paid off Janet's car. He also did various improvements to Janet's house, such as having a new furnace installed and having wood flooring laid in the kitchen. So he did quite a few things. So then they broke up, and Julie gave Cooper the diamond ring back, the engagement ring back. And then he wanted to sue to recover the value of the gifts. So do you think that Cooper should sue to get those gifts back?
Nope.
No,
He gifted them.
he gifted them. So what about the engagement ring? Is that not a gift?
It was in promise of a marriage.
Perfect. Yes. So it's something for something. So she said, yes, I'll marry you. That's a contract, right? He said, will you marry me? She said, yes, that's a contract. They got a ring that signifies the contract. There's something. Now she's supposed to marry him, right? And then that's execute. It's done. That contract is complete. And the fact that she didn't marry him signified that she should give that engagement ring back because that was something for something, and the other part of that something was not given. So
Quick question.
Wait, so does that, oh, sorry.
it's okay.
Go ahead.
Okay, go ahead.
All right, I was just curious. Wait, so does that mean like if she wanted to withhold the ring as well, could he have like actually sued for that since like it was given in exchange, or no? Because I kind of feel like that's like, honestly, like in my opinion, that's kind of weird to kind of like sue for your ring back too.
So that wasn't in the lawsuit because she'd already given it back to him. So what he was suing
It's just
for,
pure curiosity.
Yeah. So now, if you were in a situation where you were in a relationship and you gave a ring and expecting, having a promise of marriage and it didn't go through, the ethical thing to do is to return the ring, right? And if you didn't, that person could then sue for the ring because that is something. It's supposed to be something for something. It's not a gift. This is actually something that is for something. So you could go that route if you really wanted to get nasty about it. The nice thing to do would be just to return the ring and be done with the situation, right? So the reason that all the rest of the gifts are not given back or paid for or whatever is because they were done without the expectation of anything in return. Or the expectation of something in return could have been that he was living in their house. So the repairs that he did, the money that he gave, the gifts that he gave may have been for, oh, okay, I'm living in your house, so I'll take care of some stuff for you or whatever. But
So what if she did end up marrying him? What happens with the ring then? Is it still the same thing when you get divorced?
so no, because you that not necessarily, because once you have married, then the something for something is complete, right?
Okay.
So that's complete at that point. Now, that gets stickier. If she had married him, there would have been a lot of different things that would have come into play, depending on the state that they're living in, and it could have gotten really sticky with all that stuff. So, in this situation, it's gifts, and that's all it is. And you can't sue for it to retain the value or to get the value back of a gift.
So how does it work? Like, Isn't like don't some states have like that law where you don't have to be married to like
Common law.
have yeah, how long does it have to be before that takes into effect?
Some states do have it, and I think the amount of time varies, but I think it's usually around 7 years. I don't know if anyone knows off the top, but and 6 years for common law. And there are other things that play into that too. So, and we won't get into that right now, but if you wanted to look into the marriage laws, there's quite a bit into it where like you have to be sharing a house and living as man and wife, not just, or whatever, you know, living together, not just, you know, oh, we've just decided that we were married for 7 years or 6 years or whatever it is. So you have to actually be acting as if you were married. So that's part of it as well.
So you have to be living in the same household, sharing the same like bills. Sorry. Versus like a friend of mine, he has a whole separate house that he lives in, but his wife lives in it, like just down the road from him.
Yeah, so in that case, they're already married, so it wouldn't matter for the common law. But if they weren't already married, that wouldn't be something that they could use toward common law because they're not actually living in the same house.
I have a question. So the engagement ring, it was like symbolic of the contract of marrying, but are there other things that are given that are like symbolic of a contract that aren't really just like a gift, like an engagement ring?
So if you give something and you expect someone to give you something back, that's something for something, and that's not a gift. So in this case, he gave her an engagement ring with the expectation that she would marry him. So he gave her something, expecting something in return. So that's why the engagement ring is not a gift. It's actually something for something. But the rest of those items are actually gifts because they are, because he gave them not expecting anything in return. Does that make sense? Did that answer your question?
I guess my question was like an engagement ring is something we're all familiar with, and I didn't realize that that's like a contractual, like I never thought of it as like a something for something type thing. Are there like other things that like are common like that?
Not that I can think of. Anybody else? Can you think of anything that?
Maybe collateral.
Yeah, in most cases that you're dealing with collateral, you're going to be doing something with a contract, with a written contract.
Yeah, engagement is the only thing I can think of.
Yeah, that's all I can think of too. Okay. So if the consideration in a contract is based on something illegal, then the contract is void. I think I already read that, huh? Nope, no. If the contract allows one or both of the parties a choice not to perform, the contract is void. If someone is already expected to do the thing in the contract is void. So we can't have a contract where, like, I'm already expected to teach you, so I can't go, oh guys, we need to have a contract. For me to teach you and for you to learn, we need to have a contract. That I'm already expected to teach you. That's part of my position here at the college, right? So if the act that someone is contracted to complete is something that they've already completed, the contract is void. Let's see. There are some instances where a court may be permitted to enforce a contract that lacks consideration. In these cases, the promissory estoppel would be applied to avoid injustice. The elements that must exist in order to award a promissory estoppel are that the promisor must make a promise. There's reasonable expectation that the promise would rely on a promise. The promisee would rely on the promise, and the promisee actually relied on the promise and engaged in action of substantial nature as a result. And injustice would be caused if the promise were not enforced. So the example given in the book discusses a contractor who wants to submit a bid for a job. They ask their subcontractors to submit a bid for them for the work that needs to be done, and the contractor submits their bid based on the amounts of the bids that they received. And after the bid is awarded to the contractor, one of the subcontractors wants to withdraw their bid. The contractor could now stop that bid from being withdrawn under the promissory estoppel. They basically said, we promised that we would do this work for this amount of money, right? So the contractor could come back and say, you already gave us that promise, so you have to go through with it. That's our binding contract, whatever. So the promissory estoppel is there to help make sure that no injustice would be done if someone didn't accept it. So in this case, the subcontractor promised to do something, and since the contractor actually acted on it, they expected them to be able to do it. They acted on it by accepting the bid. And now if they don't have that bid, all those other subcontractors that submitted won't receive anything, and that work won't get done, and they could be sued because they've accepted this bid and now they're not going to complete it. So there's a lot of things that go into that. So they could actually, that contractor could actually be harmed by that subcontractor withdrawing that. So they can stop it with the promissory estoppel. Let's see. Chapter 11 talks about capacity and legality. And I just love that they put the Las Vegas sign on the front of that chapter. I think that's kind of funny. Okay. So in order for a contract to be legal, we talked about this, parties involved must have contractual capacity. We talked about this a little bit in chapter 9, but people that do not have this capacity are minors, insane persons, and intoxicated persons. So minors are people that are under the age of 18 or the age of majority. And they generally lack the experience needed to enter into a contract with an adult. They don't have that life experience at that point to where if they entered into a contract with an adult, that they would actually be, the adult could take advantage of them. And so because of that, the infancy, holy smokes, sorry guys, doctrine was enacted. The infancy doctrine gives minors the right to cancel contracts that they've entered into with adults. A minor can disaffirm or rescind a contract at any time prior to that person reaching the age of majority. If neither party has exchanged anything of value, disaffirming the contract is simple. However, there can be issues with it if the consideration has been exchanged. So if the minor has received consideration, the minor would then owe a duty of restoration and must return the item to the other party. If the other party has received the consideration, then they would owe a duty of restitution and must restore the minor to the position they were in before it was given. So let's say that the minor gave another party a car and they sold that car. So now they would have to give the minor the value of that car to restore them a duty of restitution and restore the minor, or I'm sorry, duty of restoration. So if a minor does not disaffirm the contract before they are considered a legal adult, the contract is ratified or accepted, and the minor is bound to the contract. The only exception to this infancy doctrine is for necessities of life. So if a minor gets emancipated, they're still expected to uphold contracts that are for the items that are necessary for them to live. So parents have the obligation to provide for that minor until they become an adult. And if they get emancipated, they are now saying, I can provide on my own. So in that case, it would be an exception to the rule, an emancipated minor, if they went in and tried to get a lease for an apartment or something like that, then they may, they have to uphold that contract. They can't say, oh, never mind, never mind. So if a person did not have the mental capacity or mental competence to enter into a contract, then they won't be bound to the contract. They must have been legally insane at the time that they entered into the contract to release their liability. There's two standards concerning contracts of mentally incompetent persons. Adjudged insane, which is when a court or administrative agency declares them legally insane. And in that case, the contract is void. And insane, but not adjudged insane. And in that situation, that's when no formal ruling about the person's mental capacity has been given, but the person suffers from a mental impairment that makes them legally insane. So in this case, the contract is voidable by the insane person. And this is common for people who have conditions where they have mental clarity on and off. So sometimes they're in their sane mind and other times they're not. So in that case, if they entered into it when they were in their insane mind, then when they come back to their sane mind, they can say, oh, wait a minute, that's not going to work for me. Let's take a look at case 11.1, Campbell versus Carr. This is on page 237 from my book. Are you guys hearing me okay?
Yeah.
205.
Yeah.
Thank you, Vanessa. Derek, I'm not sure. Is it better for you now, Derek?
A little bit, just here and there, it cuts in and out, and you're paused for like a while.
Oh, am I making funny faces? Probably.
Occasionally.
Sorry. Anybody else having any issues with me freezing up or anything like that? Okay.
Yeah, it froze up for me a little bit as well.
Okay.
Yeah, a little bit same.
All right. So we'll just keep an eye on it. If it gets worse, then we'll turn our videos off. Okay. So let's take a look at case 11.1, page 205 or 237, depending on what book you have. This is Campbell versus Carr. So what do you guys think of that one? 162,000 is what it was valued at, and they were going to sell it for 54,000. She was going to sell it for 54,000.
The Carrs were trying to get a good deal.
Yeah. Or the Campbells, yeah.
Oh, the Campbells, yeah.
Yeah. So do you think in this case that it was, that the courts were right and they, that it was a good thing that they relieved her of her contract?
Yeah,
Yeah. And what do you think about the Campbells? Do you think they acted unethically?
definitely.
Yeah.
Absolutely.
Yeah, so it seems like they were trying to take advantage of a situation, right? All right. So a contract is considered voidable if the party entered into it when they were intoxicated by drugs or alcohol. Intoxication can decrease knowledge and understanding of the terms of a contract and therefore are not enforceable if the party was incapable of understanding the terms at the time they entered into the contract. So some contracts,
How does that work with like marijuana? Because marijuana stays in your system for 30 days. How do you decipher somebody that has
so
smoked
the
pot?
person that's intoxicated would be the one that would most likely would be the one that would terminate the contract. So they would be the ones that would say, hey, I was intoxicated at the time that I entered into this. So I'll tell you a little something, and this doesn't have to be, I mean, this could be prescription drugs too, or I had surgery one time, and after surgery, I was very out of it because I'd been given some stuff, you know, while I was under. And at that point, I had a phone call from someone that wanted me to do something, and I can't even remember what it was. But we'll just say for this that it was to update my warranty, because I get those calls all the time. Update the warranty to your car, right? So let's say that they called me, and during that time, you know, I had just had surgery. I was intoxicated. I was under the influence. And let's say that I went ahead and did the warranty, and then the next day I couldn't remember. I didn't remember that I did the warranty. And then all of a sudden I get paperwork on this new warranty that I had no idea, and I paid them all this money or whatever. Then I could go and say, look, I just got out of surgery and I wasn't in my right mind and I didn't want this warranty. And I could sue for that. I'd probably in that case have to show documentation that I had had surgery. I probably would have to have my doctor or my anesthesiologist tell them what they had actually given me, or something along those lines. But I would have the right to break that contract because at the time that I entered into it, I was intoxicated.
When I worked at a dealership, there was a guy that showed up that was intoxicated trying to buy a car, and they wouldn't sell it to him because he could have gotten out of the contract.
Exactly. Well, and then you don't want him driving off the lot either. Right? You never know what's going to happen.
True.
So,
he was looking at a really expensive car too.
Right. And that's a tough situation too. I get it. But and it could be hard to understand if that person was intoxicated at the time. But if you can tell, then obviously it's not a good time to be, like, if I would have been slurring my words and, you know, maybe in and out of it, and, you know, got that phone call, then maybe they would be like, we'll call back, you know, and that would have been a smart thing to do for that company. However, if they hadn't, and if I had entered into something, I can tell you from experience that I didn't remember a lot after that surgery. So if I had answered the phone and entered into any agreement at that point, I definitely would have had cause to get that contract voided. So some contracts are considered illegal contracts, and these contracts are contrary to statutes and violate public policy. A few of those we talked about, that the ones where the contracts that have interest rates in them, and if the interest rate is changed by the state or by the federal rates or whatever, then that contract would be voided. So if a lender were to make the contract at the highest allowable interest rate, and before the contract was accepted, the law changed, and this contract would be considered void, and a new one would have to be drawn up. So notice that I said before the contract was accepted. So if it was the highest at the time that the contract was accepted and they signed their name, they wouldn't have much to go on. But if it was changed before they accepted it, then that contract would be voided and they would have to start all over. Contracts to commit a crime are illegal contracts and considered void. Some states have gambling statutes, and that's why we saw the fabulous Las Vegas sign that makes certain types of gambling illegal. In those cases, the illegal contracts are considered void. So if you entered into a contract, a gambling contract, that could be considered void if the state considers it illegal. If a contract has negative impact on society or interferes with the public safety or welfare, those are considered immoral by society, are considered void. Illegal contracts are void, so the parties cannot sue for performance. Of course, there are certain exceptions to this, including innocent persons who are ignorant of the law, a person who was induced into the contract by fraud, duress, or undue influence, a person who entered into an illegal contract and withdrew before it was performed, and a person who is less at fault than the other party. We talked a little bit about the release of liability clause that may be written into some contracts, I think on our first class. So we talked about that, like skiing, and how there's a release of liability so that if you get hurt, it's on you, it's not on them, those kinds of things. So these clauses are known as exculpatory clauses, and they relieve liability of one or both of the parties to a contract from tort liability for ordinary negligence. Let's take a look at case 11.2 on page 242 in my book. This was Sturza versus United Arab Emirates. UAE. 210, thank you.
Sorry, what page is this on for you?
242.
Okay.
I gave you guys the wrong case. I'm reading this, I'm like, what the heck? I don't remember this one. I'm so sorry. Let's try this again. I've got page 244, case 11.3, Lynn versus Spring Mountain Adventures, Inc. That will go more along what we're discussing. I'm so sorry about that. 212, thank you. 212, 244, sorry about that. All right, so release of liability was on their equipment rental, and she signed it, and then she hurt herself while she was skiing and sued them for her injuries. So let's think about this. Is it ethical for companies to use a release of liability form?
Yes.
They're
Yeah.
protecting themselves, right? I mean, they've got to protect themselves, and especially in a situation that, in some situations like extreme sports, like skiing and horseback riding, and
It's 7 o'clock.
what was that?
Oh, sorry, that was my computer.
Oh, okay. All right. And so skiing and zip lining, any of that kind of stuff, you know, these companies are going to have you sign that release of liability. And we talked a little bit about that, and how most people don't even read it. They just sign it. So in this case, that's what happened. She didn't even read it. She's like, oh, I'm so excited to get out on the slopes. I'm just going to sign away and I'm out. And so then when she sued, they're like, well, wait a second, you signed a release of liability. And the court said, you signed a release of liability. They're not responsible for your injuries. So what would the consequences be if persons were held not to be bound by contracts they did not read? So that's a great question. So
everybody would get away with everything.
Yeah, I mean, if we weren't bound to what we were, you know, you're supposed to read it. You're supposed to sign that I've read. Most of them even say, I've read and understand the contents of this contract or whatever, and then you have to sign it. And so if you didn't read it, that's on you, right? You should have been reading it the whole time. So, all right. So how many of you guys have heard of a non-compete? Have you had to sign one ever? Okay. So what a non-compete is another form of protection for a business, and it helps. It's there to help the business retain the knowledge that they impart onto an employee. So let's say that I work for a tour company, and we have certain clients that come to us all the time. And I decide, you know what, I'm leaving and I'm going to start my own tour company. And before I leave, I grab their customer list so that I can contact all those people and say, hey, you remember me? I now started my own tour company and I want you to come over to me. A business wants to protect from that, right? Because they don't want to lose all their customers. They want to be able to retain those customers. So they may have you sign a non-compete, which means that you will not, and they're all worded differently, but basically what the gist of it is you would not enter into a similar type of business after leaving their firm or that company. So the person that signs the non-compete is then restricted from competing with that business for a certain amount of time after their termination from business. I've never seen one that is not got some sort of time stamp on it. So they've all got some sort of amount of time that you would be held to that. And then after that amount of time, 2 years, 5 years, whatever it might be, if you opened up a new one, then at that point it's okay. For a non-compete to be lawful, they have to be reasonable in 3 aspects. So the line of business protected, the geographic area protected, and the duration of the restriction. So they have to say they can't open up a tour guide business in Page, Arizona. So that's the geographic area, and for 2 years. So now I've got all those things for that non-compete to actually be effective or lawful. Sometimes the contracts are non-negotiable, and you have to sign it in order to get your product or service, which are called contracts of adhesion. So if you're buying or leasing a vehicle or a home, or you're renting a home, those types of contracts are generally non-negotiable. It's, you know, your home is going to be at this amount of money, and once you sign it, then you're entered into that contract. Or you go to buy a car and maybe you haggle a little at the sales floor, but when that contract is written up, it is this amount of money. And then of course they tack on all the other crazy stuff to get you, right? So I hope nobody's in here. Nobody here is a car salesperson, but but
No, but I worked there.
What was that?
I said no, but I've worked at a car dealership for many years, so yes.
Yeah, I
It's
mean,
crooked.
every time I go in, and oh, it gives me a headache sometimes. You know, you go in, you're going to buy this car, you say, okay, this is the amount I want to pay for it. You go in, and then all of a sudden, it's so much more than you thought it was going to be, and you're like, what am I signing right now? You know, so you got to be careful and watch for that. But those are generally non-negotiable. Sometimes people enter into contracts where one party is more dominant, and they are likely taking advantage of the weaker party. The enforcement of some of these types of contracts can be refused by a court in whole or in part because it contains oppressive or manifestly unfair terms, which make it unjust. And this is called an unconscionable contract. The elements needed to prove that the contract is unconscionable is that the parties are unequal in bargaining power. The dominant party used its power to obtain oppressive or unfair contract terms, and the adhering party had no reasonable alternative. Let's take a look at case 11.4, Stoll versus, on page 246. 246, yeah, 246, sorry. Okay, so this one is another property situation, right? And let's just get down to it. Did Stoll act ethically in this case?
No.
He's asking for over the prices that are going in the area, right, already. So that right there. And then he's, you know, taking advantage of the situation. Were the buyers taken advantage of? We just answered that, yeah. Should the buyers have employed a lawyer to represent them to protect them against unethical conduct?
Yes.
That would have been smart, right? Especially since they didn't really understand too much. So that would have really protected them if they would have had somebody on their side that could have helped negotiate those deals, and they might not have had to pay so much, right? My dog thinks class should be over. She just came running in and is nosing me right now. So sorry about that. Let's talk about chapter 12. This one has a bunch of information in it. This is genuineness of assent and statute of frauds. I told you we were going to talk about that more. So this one's going to talk about more about the contracts that need to be written, that need to be in writing, that we were talking about earlier. So the assent given to make a contract must be genuine. This is called genuineness of assent. And if the assent is not genuine, it would be considered to be based on fraud, a mistake, or duress. So fraud is an event that occurs when one person consciously decides to induce another person to rely and act on misrepresentation. The elements needed to prove fraud are the wrongdoer made a false statement, the wrongdoer intended to deceive the innocent party, and the innocent party justifiably relied on the misrepresentation, and the innocent party was injured. There are several types of fraud, including fraud in the inception, which occurs if a person is deceived as to the nature of their act and does not know what he or she is signing. So do you think that's what we were dealing with in that last case?
Yeah.
Fraud in the inducement, which occurs when the party knows what they're signing but has been fraudulently induced to enter into the contract. Fraud by concealment, which occurs when one party takes specific action to conceal a material fact from another party. So not disclosing all the facts to the other party is not uncommon. However, silence can be a misrepresentation if the non-disclosure would cause injury or death. There is a relationship of trust and confidence between the parties, or federal and state statutes require disclosure. So for example, sometimes things are required to be disclosed, like in the instance of a sale of a home. In some states, you have to report if there was water damage in the home, if there are any structural problems of the home, or if it's ever had structural problems, and if other things like if someone's even died in a home. We have a situation where our neighborhood is still being developed, and there was an accident so there's a street that comes in and it does a T like this, and there was an accident. Someone ran into the dirt lot and ran into a big pile of dirt that was in that dirt lot that's right actually behind my house. And we have to actually, but the people that are selling the houses here have to actually disclose that there was an accident there, and that could be cause for concern if they build a house in that lot, in that vacant lot. So there are situations when you would be told that you have to give that information. Misrepresentation of the law in a contract is not usually considered fraud unless one of the parties is professional and should know what the law is and intentionally misrepresents the law. Innocent misrepresentation is fraud that occurs when a person makes a statement of fact that they honestly and reasonably believe to be true, even though it's not. Let's take a look at case 12.1 on page 254 in my book. This is Crissa versus Payne.
13 owners is a lot.
What was that?
13 owners? That's how much that truck had?
Yeah, yeah. As opposed
It was
to
a 2-for-1 deal.
Yeah, yeah, no kidding. So yeah, do you think Payne, the used car dealer, acted ethically in this case?
No,
Nope.
not at all.
No.
They should have asked for a Carfax, so before purchasing it, not just word of mouth.
Right, I agree completely. Why would you not, and I would think there has to be some sort of evidence that these two cars are put together. I don't know.
I would have taken it back once it was having trouble starting.
Yeah.
Not only that, it's his choice. He did a bad job inspecting the vehicle before he got it.
Yeah, that's what I mean. I think that, it could have been pretty evident. I guess I'm kind of picky. Like I go through the vehicle and I'm noting things that are just ridiculous. My husband looks at me, he's like, really? I'm like, yes, really. There's a little teeny tiny scratch right here.
Because they do that to your trade-in.
What was that?
They do that to your trade-in to devalue it. And that's how they rob you for your trade-in.
Right. They're like, oh, there's a little scratch here. So we're gonna dock you $1,000 for this little tiny scratch.
Yeah, so then you start thinking, oh, well, my car's probably not worth that much. And so they just start taking thousands of dollars off.
Yeah. So do you think punitive damages should have been awarded in this case?
Yeah.
Yeah, they were put in an unsafe position. I'm not sure $500,000 of punitive damages, but this guy was he was obviously out to deceive, right? He knew that this car wasn't all that when he sold it to him. So yeah, 500,000 is a little much, but I think, in my opinion, just because I feel like there's some responsibility on Chris's to make sure that their vehicle is a decent vehicle, right?
And the headache and frustration that they went through in trying to fix things that were starting to go wrong, that's time and money right there.
That's true. That is true. So, the court awarded it, so it must have been worth it.
When I go to buy a vehicle, I go as far as checking the oil and crawling underneath it.
Yeah, depending on the vehicle, for sure. Yeah.
And down to checking the air pressure of the tires too.
Mm-hmm.
My auntie was gonna buy a truck. I happened to crawl underneath it, and literally the whole bottom of the truck was just drenched in oil. But when you popped the hood, the engine was like clean, but underneath the truck wasn't so clean.
Yeah. Yeah.
Yep.
So you just got to be careful, right? You got to look out for yourself. Especially with those shady car dealers. No, I'm just kidding. I'm just teasing.
That dealer said they had like a 3 months like engine warranty or something like that, and I'm like, nope, that ain't gonna fix that.
Yeah. So
yeah, because then you're out of car for however many months it takes for them to repair it.
Yeah, that's true.
If they can repair it.
Okay, so moving on. A situation in which one party threatens to do a wrongful act unless the other party enters into a contract is known as duress. So like if I said, if you don't sign this contract, I'm going to give you a bad grade. That would be duress. If physical harm is threatened, then it's known as physical duress. In a situation in which one person takes advantage of another person's mental, emotional, or physical weakness and unduly persuades that person to enter into a contract, the persuasion by the wrongdoer must overcome the free will of the innocent party, and that's known as undue influence. So we talked about this a little bit, there are a lot of contracts that are required by the statute of frauds to be in writing. And the statute of frauds is what stipulates how certain types of contracts are presented. And some need to be in writing. Some have more stipulations like the form the signature must be in. So it just really depends on that contract. And the types of contract that must be in writing are contracts involving interest in real property, contracts that by their own terms can't possibly be performed within 1 year. And these are on page in my book 255 and 266, or 255 and 256. Collateral contracts in which a person promises to answer for the debt or duty of another, promises made for in consideration of marriage, contracts for the sale of goods for $500 or more, contracts for the lease of goods with payments of $1,000 or more, real estate agents contracts where the underlying contract must be in writing, promises to write a will, contracts to pay debts barred in the statute of limitations or discharged by bankruptcy, contracts to pay compensation for services rendered in negotiating the purchase of a business, and finder's fee contracts. When dealing with contracts involving interest in real property, it's important to note that the real property is the land, buildings, trees, soil, timber, plants, crops, fixtures, and other things that are permanently affixed to the land and buildings. If it's permanently affixed to the land or building, it is considered part of the real property, even if it is personal property. So if I went into a house and I affixed, well, let me give you this example. So I told you guys I worked for an appraiser's office at one point in time. And we had a situation where one of the appraisers went out to appraise a house, and this guy that owned the house had constructed this really cool train set and a train track. And the train track went all through the house, and it went through, like, he had carved little tunnels in the walls where it could go in the wall and out the wall and back around and do all this crazy stuff. At that point, he's affixed it to the property. And at that point, it can be considered part of the real property. So that could make it so that he can't keep that, or he has to fix the walls and fix all of that where the train track was put in. The most common of these contracts is a mortgage and lease, or lease. A mortgage is written up when you're financing real property from a lender, and a lease is written up when you're transferring the right to use the real property for a specified period of time. How many of you guys have heard of an easement? Yeah. Okay, so an easement is the right to use someone else's land without owning or leasing it. This is very common in city government properties or city governments. So for example, we have an easement in the front of our house for 20, I think it's 20 feet is our easement, or maybe it's 15. Now I can't remember, but we can't build a building on the first 15 or 20 feet of our land. It has to be set back further than that for us to build the building. And that's an easement that is set by the city. And that easement is for them to be able to access certain areas on the property. It's for them to have the sidewalk in front of the house, all that fun stuff. So there are easements, there are situations. We also have a really weird situation here in Page. These houses are, some of the houses are older, and they're built in these areas that have these, well, they're called easements. They have these little driveways that go back behind the house, and several properties back behind there can access those. And those easements are not available for sale, and they don't belong to any of those property owners. They belong to the city, and the city has the right to go back there. In some cases, there are power lines back there that they need to access. In some cases, there are water mains back there that they have to access. There's certain things that are back in those little areas that they have to access. And so there are easements that they can't, nobody can build on them. Nobody can, they're restricted.
So does that mean that you can't do additions to your house as well?
We can in the back. We cannot in the front.
Okay.
So we can,
okay.
well, I take that back. I think we're set back 10 feet more than we had to be. So we could actually build something 10 feet forward in our lot and not be outside of that easement. But we can't build any structure beyond that amount of easement.
Okay.
A court may order that a oral contract for the sale of land or transfer of another interest in real property to be specifically performed if it has been partially performed and the performance is necessary to avoid injustice under the equitable doctrine known as part performance. So there's a case on page 257, and I'm just gonna, we're gonna skip that one because I really want to get through the rest of this and to the homework so we can discuss that a little bit. So when you have time, if you want to check that out, it really explains part performance pretty well. And that's on page 257 in my book. It's Sutton versus Warner. So promises made in consideration of marriage. We talked about this in depth. But does anyone know what kind of contract this could be that I'm talking about now? What kind of contract would we have to have written in order to get in consideration of marriage? So we're thinking about getting married. What kind of contract would you think we would have to have?
Would that be like a prenuptial agreement?
Yes, exactly. So we may write up a prenuptial agreement saying, this is my property, this is his property, or whatever it may be, and this is our joint property, or however that prenup comes out. A promise in which one person agrees to answer for the debts or duties of another person is known as a guarantee contract. In this situation, there are 3 parties and 2 contracts. Case 12.2 on page 259 in my book, Page versus Gulf Coast Motors. This one is about a guarantee contract. And I do want to quickly look through this one. It's short. So if you guys want to take just a minute and, or I can just read it real quick. So Glenn Page had a long-term friendship with Jerry Sellers, an owner of the Gulf Coast Motors. Glenn began borrowing money from Gulf Coast Motors on a recurring basis during a 2-year period. There was no evidence as to what Glenn used the loan proceeds for, but evidence showed that he had a gambling problem. Sellers testified that toward the end of the 2-year period of making loans to Glenn, he telephoned Mary Page, Glenn's wife, and Mary orally guaranteed to pay Glenn's loans. Mary had significant assets of her own. Mary denied that she had promised to pay any of Glenn's debts, and she denied that Sellers had asked her to pay Glenn's debts. Gulf Coast Motors sued Glenn and Mary to recover payment for the unpaid loans. The trial court entered judgment in the amount of $23,020 in favor of Gulf Coast Motors. Mary appealed. So the issue was Mary's alleged oral promise to guarantee her husband's debts an enforceable guarantee contract. And the court said a promise to pay the debt of another is barred by the statute of frauds unless it is in writing. Mary's alleged oral promises are not enforceable under the statute of frauds. We conclude that Mary's alleged promises to guarantee or repay Glenn's debts were within the statute of frauds and therefore were not enforceable. The Court of Civil Appeals held that Mary's alleged oral promises to guarantee her husband's debts were not in writing as required by the statute of frauds, and the court remanded the case to the trial courts to enter judgment in Mary's favor. So what is the public policy for requiring guarantee contracts to be in writing? Well, we just talked about that. That's the statute of frauds, right? So did Mary act ethically if she made an oral guarantee promise and did not honor the promise? Here's an opportunity where the law and ethics kind of split a little bit, right? Like we talked about before. So in this case, ethically, if she said it, she should do it, right? I mean, that's how society feels most of the time. If you promise something, then you should act on that promise. And in this case, she didn't. So, but the law says that that promise had to be in writing. So if she did say it and she knew that it had to be in writing, she could have said it just for that and, you know, maliciously or whatever. So, when entering into a contract, most of the time the parties have had a discussion before the official contract is drawn up. This may have been orally or in writing or by email or whatever. In those cases, if the information in the prior conversations that contradict, alter, or are in addition to the terms are not admissible in court. This is called the parole evidence rule. Of course, there's exceptions to this rule. If the prior communication shows evidence that the contract was induced by fraud, misrepresentation, or whatever, the prior communication, if the prior communication explains ambiguous language, if it concerns a prior course of dealing or performance between the parties, if it fills in the gaps of a contract or corrects an obvious clerical error. Case 12.3 deals with this. We're not going to read this one either. In my book, it's on page 262. But this one talks about the parole evidence rule. And if you get a chance, that kind of talks a little more about that. It's kind of an interesting case. So you should check it out. If the parties enter into an oral contract that should be in writing according to the statute of frauds, the contract could be enforceable under the promissory estoppel. If the promise induces an action by another, the reliance on the oral promise was foreseeable and injustice could only be avoided by enforcing the oral promise. Okay. So the assignment that we're going to talk about is ethics case 9.5 in your book, I believe, and 9.6 in mine. This is Chenard versus Marcel Motors. And in my book, it's on page 214.
182 on ours.
Thank you. 182. So this is an ethics case. It has a few questions. So I'm just going to go over a couple of things with the rubric. So again, you're going to define the legal issue of the case. So you're going to research the case and explain the conclusion. And then you're going to answer the questions. And it looks like there are 1, 2, 3 questions in here. You're going to give your opinion of the case and support your opinion with two-cited sources. And you're going to use correct grammar, punctuation, and spelling. And it's Times New Roman 12-point font, double space. Completed assignment should be 1 page. That's pretty much it. Those are the things that I'm looking for, and anything above and beyond that is to your discretion. So are there any questions on this assignment?
Is it basically like the first one that we did?
Yes. So the rubric in all of the assignments are exactly the same. So I'm going to be looking for the exact same thing in all 5 of the assignments that you get. So, and like I said, after I grade this one, which I'm planning on getting it graded tomorrow night so that you have it quickly, you have the feedback quickly, and you know what to expect with the second assignment. So once I have that down, you'll have a good understanding of the expectations for the assignments, and you'll know how to proceed on each assignment going forward. Vanessa, did you have a question?
No, I was just unmuting. I was gonna say something and then you clarified, so
Oh, okay.
we're good. Thank you.
Okay. Any other questions?
And you said to clarify, your citation should be separate, just kind of how we would do in a writing class, right? Like,
Yeah. So
type-
I'm not. Sorry. Go ahead.
Just have a title and then your source is cited or whatever.
Yeah, so I'm not a stickler for citations, but I do want it, like if you're quoting it directly, I want you to put the citation up where you're quoting it, put the something saying this is the citation I used when I quoted this. And then down at the bottom, you would just put the full thing, just like a normal citation. If you're not citing it directly, you would just put the citation at the bottom, the whole citation. But as far as formatting, MLA, APA, whatever, I don't care either way, whatever your discretion is, and you can make it as crazy as you want.
You mean at the bottom of like the whole assignment, do the 2 citations?
Yeah, that would be great just to have that, so that, like, let's say that you use a website. In the thing you might say, let's say Forbes, you used Forbes. I don't know why that came to my head, but Forbes. So you would put Forbes wherever you quoted it, if you quoted it, and if you didn't, you just put the Forbes, what you use to get your citation, or what you use to get your information, down at the bottom. If you didn't do that this time, don't worry, because I'm not going to dock you on things that I haven't already told you. So because we talked, that question came up today in class, and those were already turned in, I'm not going to dock you for that.
Cindy, for that first assignment, or if we did anything wrong, would you like make like a little note how we fixed it?
Yeah, so I will be giving feedback.
That's what I was curious about, actually, was if I was formatting it right, like how you would want it.
Yeah, I'll give you feedback. So if I see something that I would rather it be some other way, I would let you know. But if it looks good, most likely your feedback is just going to be looks good, and that just means that you've checked all the boxes that I was looking for, and you're good to go.
All right, thank you.
I have a question, Cindy.
So
with mine, the way I formatted mine, my citations, I did it to where I could insert actually a hyperlink into a superscript, and then I did actually footnotes explaining why I used that particular source, or kind of explained it a little bit. Is that something that's, I just figured that might be a little bit easier, considering you could just click right to the website if you wanted to.
I'm definitely not going to dock you for that.
Okay.
Anybody else?
Yeah, I do have one more question.
Okay.
For the test being about 2 weeks from now, is that just over part 1, or is it going to be over chapters 9 through 12 as well?
So we are going to talk about that test at the end of our exam. I'm going to call it an exam. I get test anxiety, so we are going to talk about that one at the end of class next week. It will be over parts 1 and parts 2 all the way through. So everything that we cover up to the exam. So chapters 1 through 15. And we'll talk a little more about that, and I'll give you some ideas of the structure and all of that next week. We'll dive into the exam and what it's going to look like. But I can tell you guys, you don't have anything to worry about.
So, including the homework, do you want us to read chapters 13 through 15 for next week?
Yes, please.
Okay.
Cindy, did you take attendance?
I'm sorry, what was that?
Did you take attendance?
Yes, I did. I actually, thank you so much. I did that as everybody was coming in. I was able to just go ahead and mark off who was here. So I was able to get attendance. Thank you so much for checking. Anyone else have any questions? All right, that's it for today. I will see you guys next week. Have a great weekend. And I'm sure you'll be hearing from me as far as assignments are concerned. All right, bye.
Bye.